మరి ఎవ్రీథింగ్ ఓకే బట్ ఇక్కడ వస్తుందా?
ఎస్ సార్ లైవ్
ఏదో మాట్లాడుతా అంటే అది వస్తుందా?
లైవ్ లైవ్
ఇక్కడ కింద లైవ్ వస్తుందా? దీంట్లో పెట్టారా? ఏదో మాట్లాడుతుంటే లైవ్ కిందకి వస్తుందా? రెండు చోట్ల ఓకేనా? రెడీ అయిపోయింది కన్నా
కింద పెట్టుకున్నాం, కింద అరేంజ్ చేసాం.
ఓకే ఓకే.
My dear students, good morning to all of you. Now, today we have a special lecture on crime and crime investigation by our High Court Advocate B. Shekhar Reddy garu. Previously, he worked as commercial inspector in railways and also in the vigilance department, railways. And later, he took voluntary retirement from the central government and then started practice. He also did Ll.B. from the institute where I have studied, that is Sri Krishna Devaraya University, Anantapur. It's my native district also. Now I request B. Shekhar Reddy garu to deliver lecture on crime and investigation because he is well versed in this subject, and I hope and trust all of you will be highly benefited as you are going to start your career as advocate.
Switch off all mobile or silence.
And the other important thing is all the students must switch off your cell phones, please, and kindly maintain high silence because it is a very important subject. When you step into the profession, you must follow this. So that is the reason why one by one I am introducing and making you to learn how you can proceed in the practical life as an advocate. So kindly maintain high silence. Nobody is allowed to speak or make any gestures also. Please switch off your cell phones and kindly listen to him very carefully because today's lecture is very, very important for you. And with this, I request my friend Mr. B. Shekhar Reddy garu to deliver lecture on this. Thank you, one and all.
My dear students, when I was asked to give a lecture on crime and investigation, I thought it very relevant in the context of the Indian legal position. Number one, I observed in the Indian society there is dearth of good criminal law practitioners at the lower courts level. My lecture today deals with major factors involving a practical lawyer at the lowest court level. Only when you are successful as a good practitioner of law at the lowest level of judiciary, you cannot gallop to the heights of even the High Court or the Supreme Court. So this is the basic foundational lecture for your career. that is the first stepping stone to success in your career. Number one point I raise is, what is the lowest court called in the Indian judiciary in the context of criminal law? I have observed in lower courts that many of the people do not make a distinction between the designation of a junior civil judge and the designation of judicial first class magistrate. This is my first observation. Because if you take the hierarchy of Indian judicial system, the apex court is the Supreme Court, the next stage is constitutional courts called high courts. There are 21 high courts in India, and thereafter comes the district judiciary. At the district judiciary level, cities, in cities, that is commissionerates, the designation of judicial officers are different from the rural areas. In the rural areas, we fall under the rural area. In the rural areas, the district judge, that is principal district judge, is the head of the administrative unit of the district judiciary, and additional district judges are also of the same rank but juniors in cadre. Principal district judge is a selection grade cadre, and when an additional district judge is free from any controversial SR, service record, then only he will be given the post of a principal district judge. Even this is not known to many of our practical lawyers. See, when there is a clearance with regard to the confidential reports or annual reports of an additional district judge, he will be eligible for the selection grade of a principal district judge. And below that, there is assistant sessions division. That assistant sessions division is otherwise called in the civil law principal senior civil judge. That is assistant sessions division. Below that is the junior civil judge, and in criminal law that designation is judicial first class magistrate. If there are more than 2 judicial first class magistrates in a town, the senior most will be designated as the principal judicial first class magistrate, and the others will be given the number. The first additional judicial first class magistrate, second additional judicial first class magistrate, like that, any number will go. This is for the rural administration of justice. In cities, commissionerates, that is called commissionerates. In the commissionerates, chief judicial judge, that is metropolitan judge, chief judge, that is principal district judge cadre. Metropolitan judge, additional district judges cadre, and metropolitan magistrates, chief metropolitan magistrate and additional metropolitan magistrates. But we have to make a distinction between these designations simply because in cities, the devolution of powers with regard to the imposition of punishment as per the criminal law varies. Though the designations varied, the powers of punishment also will vary. These factors will be known to you all only when you go through the earlier chapters of your criminal procedure code, or even the chapter on punishments in Indian Penal Code. Otherwise, you will not make a distinction in all these matters. I have seen in several cases that some of the magistrates also are not aware of these distinctions. That is the standard of legal system in India. Even in the judicial academy, they are not properly taught. In one of the recent cases I have got, a judicial magistrate imposed 26,000 rupees penalty on the accused at the time of conviction. But if you go through section 29 class 2 of the criminal procedure code, the power of a first class magistrate to impose fine is only to a maximum of rupees 10,000 rupees. So, my point here is that as a practical lawyer, unless and until you know all these factors as per the law envisaged in the acts and codes passed by the parliament, you cannot make a good lawyer. It is your duty as a good lawyer, practical lawyer, to correct the judicial officers wherever they go astray, take a wrong path. That is why your role as advocates, especially at the lower courts level, is paramount in my opinion. Therefore, you must first be well versed with the legal position, and also you should, by the by, maintain good standard of presentation. Presentation requires language. If you have effective language, you can present your case effectively. So, this is the introduction to my lecture. Why I want to take care upon the posterity, that is future generations, because our judicial system lacks or does not have sufficient number of efficient lawyers. So I want to train you as a good, practical, efficient lawyer, especially at the lower court level, because what happens at the lower court level is money pays many roles. So if you give some money, automatically there may be a false case against anybody, however big he may be, or the politics is played foul. Whoever is in power will make use of the political power and book the criminal cases. The criminal case is brought into the fore to dislodge some of the very important constitutional functionaries also. That is why you should know criminal law to the deepest levels. I don't want to take examples from the present day events, but generalization is my principle. If you go into the statistics of abuse of law, here abuse, the word abuse is to be explained, because most of the people think that misuse or abuse, both are similar. In my opinion, not just my opinion, it is the opinion of the Britishers who coined English language, that's vocabulary. Abuse is a word used in the context of using badly the machinery of administration, knowing pretty well what is the just, reasonable and fair administration of justice. Knowingly they use, that is abuse. Misuse is ignorance, not knowing what is the procedure or the law. They apply the law, that is misuse. Therefore, whenever you know the procedure of law and that procedure is not being followed by the machinery of administration, then you have to use the word abuse, not misuse. Okay? Here, in the Indian context of criminal law, in the lowest level of police administration, mostly criminal law is abused. How it is abused? You have to be in a position to explain before the court of law. If you don't clarify how the machinery is being abused, you cannot be a successful lawyer. In order to become a successful lawyer, you should know some of the words which are to be used in their appropriate sense. For example, let us come to Article 13 of the Constitution of India. I hope you all might have cleared that paper of constitutional law in the first BL itself. Most of you might have clear the paper also. Therefore, I attract your attention to know what is law, what is meant by law. If you go to Article 13, Clause 1, whatever laws were there prior to the Republic Day, that is adoption of the Constitution on January 26th, 1950. The full Constitution came into force only on 26th January 1950. Parts of the Constitution came into force on 26th November 1949. Therefore, we have to say that the Constitution of India had come into full force only on 26th January 1950, and the word law also has come into force on that particular day. What is law? In Clause 1 it says, whatever laws were previously in existence which are not in conflict with the Constitution only is law. And whatever laws are adopted into the Constitution, and if they are, Clause 2, if they are not in conflict with the Constitution, then only those laws are valid. Otherwise, they are void. Both, you know the meaning of void, which is explained in the Contracts Act. I need not harp upon that word. Number 3, Clause 3, Article 13, Clause 1, A, B, C. C deals with certain words which constitute the meaning of law. Number 1, ordinance, notifications, bylaws, rules, regulations, customs and usages of the society which have the force of law. These words are all to be carefully used. Whether one particular word used in the administration is law or not, we have to understand. Let us come to magistrates court level, where the prosecution is represented by the public prosecutor through the police of the station, and the accused is represented by his counsel. If he is not in a position, economic position to engage the services of an advocate or counsel, state aid will be given. That is, I hope you know pretty well. And state aid advocates or counsels will be representing the accused. To this extent, you are all clear. See what the police come to say at the critical moment in some of the cases which observed in the High Court. APPM, Andhra Pradesh Police Manual. Like that, some other states, Tamil Nadu Police Manual, Kerala Police Manual, every state will have that police manual. They bring police manual into the discussion. Our manual says so. Now my point is a manual law? What are instructions given in the manual? Does it have the force of law? No. You have to go to Article 13, Clause 1, Subclass 3. The words used, notification is a law, bylaw is a law, when ordinance is a law, act is a law, rule is a law, regulation is a law, but not circular or manual. Circular is issued by the department, does not have the force of law, does not have the law. Law in force is used in Article 13. So it is not a law in force. It is only an instruction given to the subordinates by his master. Master's instructions to servants. If in violation of the law, he is not valid. So such things you have to critically examine while you represent your accused. Article 13. Number 2, you have Article 20. There are 3 doctrines in Article 20. What are they? Number 1, doctrine of ex post facto laws. Number 2, doctrine of double jeopardy. Doctrine of self-incrimination. Yes, good. People are recollecting what they read. That is correct. What is an ex post facto law? I tell you, this is integral part in this lecture, devoting time for about 30 minutes, because if you come into practice as an advocate at the lowest court level without the basic knowledge of these things about the Constitution, you are an utter failure. Because whatever magistrate, maybe one of your friends as much knowledge as you got, would have become a magistrate by extraneous reasons. That is not important for us. So in such a situation, you have to guide them. I tell you my practical approach to some of the magistrates. Very recently, I hope the 20th of March, one magistrate asked me, you have involved public servant as a proposed accused in this case. How is it possible? Should we not get permission? Then I cited a very latest judgment of the Bombay High Court, Professor G.M. Sai Baba case. Most of you might have read in newspapers that Professor G.M. Sai Baba is the professor of English in Delhi University. He was booked in a Bhima Koregaon case. Charge sheet had been filed under the UAPA, a special criminal law. So permission was not taken, but he was convicted by the special court, designated court. So conviction was set aside by the High Court on the ground that no permission had been obtained. That is the fundamental reason why the Honorable High Court of Andhra Pradesh did not take cognizance of the offence charged with and set aside the conviction. Now, Delhi University is in a critical position because I know as a specialist in service jurisprudence, when permission was not granted, his entire service, entire period of incarceration should be treated as in service and pay all his pay and allowances. See, a professor of a university will get not less than 2 lakh rupees per month and 24 lakhs per month into 10 years. So 24 lakhs per annum into 10 years. What is the amount? Nearly 2.5 crores, more than 2.5 crores. So that is the critical issue. Here, we have a right to comment upon the cases. When once we enter into the profession of law, that is called in your classes, they call it case comment. If the case comment is fair, just, reasonable, and it is truthful, no action can be taken against any advocate, even for contempt of court, for the simple reason Section 13 Clause 2 Contempt of Court Act clearly says that there cannot be contempt for truth. This amendment had been brought forth into the Contempt of Court Act after the conviction of the famous Raman Magsaysay Award winner and Booker Prize winner Arundhati Roy, God of small things. She opposed Justice Gopala Ballabha Pattanayak and she said that I want to apologize to this honorable court because there is a split verdict between the two courts in the same issue and therefore it is a mistake committed by this court. Narmada Bachao Andolan case. In Contempt of Courts Act, it is a milestone or landmark judgment which brought change in the Contempt of Courts Act. So such things can be raised only when you are a good practical lawyer. as a good practical lawyer, here the issue now coming to Professor G.N. Sai Baba's case, when his discharge petition was allowed, criminal law, special criminal law, discharge petition was allowed, the Honorable Supreme Court reversed the order of the High Court, and now the order of the High Court had become final, discharge had become final. Now people started commenting upon the performance of the judge who passed the order in that particular case. So in such situations you are the beacon light, that is beacon light. Do you know what is the meaning of beacon light? Beacon light is a light used in the navigation. It will give the sailor the direction in which you have to go. That beacon light will show you the place where you have to approach. So that is guiding light. You are the guiding light in the criminal law. So now for the purpose of criminal law application, we have to divide criminal law into two categories, bifurcation. One is general criminal law. Number two is special criminal laws. What are they? Indian Penal Code is a general criminal law, substantive law. Criminal Procedure Code is a general procedural law. What about Indian Evidence Act? Is it a procedural law or a substantive law? Substantive law. How many of you opt for a substantive law? How many of you opt for procedural law? You are in a dilemma. So Honorable Supreme Court declared the Indian Evidence Act as a procedural law in one of the judgments. So it is a procedural law. Whenever any crime is registered and the investigation is to be taken up, these two procedural laws are to be observed by the investigating agency. I use the word investigating agency because in case of special laws, these ordinary civil police are not fit to investigate the case. In special laws, there is very specific rank officer who has to investigate the case. For example, NIA case, National Investigation Agency case, an officer of the rank of Superintendent of Police and above only should investigate the case. For example, SC/ST Atrocities Prevention Act. In that case, an officer of the rank of Deputy Superintendent of Police and above only should investigate. In case of Information Technology Act 2000, only an officer of the rank of Inspector of Police and above should investigate. Even in general criminal law procedure, criminal procedure code, some of the offences like murder must be investigated by an officer of the rank of Inspector of Police or above. First of all, you should observe the ranking. Likewise, you have to observe the division of the crimes, punishments to be imposed. Now, you understand what is Article 20 ex post facto laws? Do you want me to explain that? I will explain. Otherwise, I leave it. And double jeopardy and doctrine of self-incrimination. These three factors are the most important aspects for a practical lawyer. Generally, you don't come across the problem with regard to doctrine of ex post facto laws because the amendments and other things carried out very, very rarely. Now we have to discuss what is the impact of all these Bharat designations changed, Indian Penal Code, Indian Evidence Act, Criminal Procedure Code, which is likely to come with effect from 1st July. So all those. Then the question of this ex post facto law will arise. Whether this act, for a simple reason, somewhere I read that death penalties, 12 death penalties in the previous Indian Penal Code had been enhanced to 18 death penalties. But that is leave apart that particular part. The question of ex post facto law will come into controversy after 1st July, because there are several punishments enhanced in the new law. You know pretty well that section 106 class 2 Indian Penal Code had been on hold even before that Bharat Shiksha Samhita has come into force. So such things will be there, and therefore you have to specialize on ex post facto laws, particularly in the context of these new criminal laws which are coming into force on 1st July. Then only you will be a successful practical lawyer. Number 2 is double jeopardy. Double jeopardy, you have connection to section 300 of the Criminal Procedure Code. Double jeopardy means no two punishments for one and the same offence. No two punishments for one and the same offence. Those are called, even if one is not punished, he should not be taken up again for trial on the same offence. The offence is defined under section 40 of the Indian Penal Code, and you understand whatever is punishable under this act is an offence. So you are not supposed to do anything contrary to, and you should not commit any omission to do certain things. Both are offences only. Whatever Indian Penal Code had told you, you should observe. Otherwise it becomes an offence. So this doctrine of double jeopardy has two aspects. Mostly people think of only particular aspect, no two punishments for one and the same offence. But suppose one had been acquitted. For example, I give you one section of law, 498A, 494 bigamy. In families, when there are troubles, their trouble is simple, that we don't want to discuss on the stage. There is a marital disharmony between the wife and husband, and it is leading to criminal cases, divorce cases, maintenance cases, whatnot, everything. Recently, domestic violence cases. So when that comes to discussion, section 17 of the Hindu Marriages Act prohibits a second marriage where there is a subsisting marriage. One marriage is valid legally, there cannot be another marriage, bigamy, second marriage. That 494 also bigamy only. So one perverted liar, if this woman goes to that perverted liar, what he will simply say, in one place we will find 494 offence case, 200 complaint. In another court he will file section 17 offence. Is it not the same subject matter? Suppose in one case he is acquitted. After acquittal he files another case. So that is called, even after acquittal, one should not be tried again for the same offence. That is called apophis acquit, apophis convict. So this also has some doctrine, maxim. So such maxims also you should inculcate to develop. That maxim, nemo bis hebe vexavis. There cannot be vexatious litigation for one and the same subject matter. That doctrine simply says that section 20, article 20, clause 2. So 3, the police cannot force you to record a statement which makes yourself an accused person. The doctrine of self-incrimination. So the doctrine of self-incrimination you will find in the criminal procedure code from 154 to 176, there are certain sections which prohibit a police person taking statement from you which will inculcate section 25 of the Indian Evidence Act. No person shall be made to make a statement which makes him an accused in the case, accused for the offence. Okay? Section 25. But there is a bar to section 25 in section 27. To some extent, so all these aspects, one by one, we have to discuss in a classroom. So all this, afterwards comes Article 21. Article 21, what does it say? No person shall be deprived of his life and personal liberty except by procedure established by law. Okay. Here you have to understand what is the meaning of person in the context of the constitutional law. What is the meaning of person in the context of constitutional law as used in Article 21 of the Constitution? Can anybody explain? Person. Simple. I repeat the same sentence with substitution of word person. No citizen shall be deprived of his right to life and personal liberty except by procedure established by law. What is the distinction between these two? No citizen shall be deprived of his right to life and personal liberty except by due procedure established by law. A citizen is one who has a right to voting right in India. That for that person only, when the context of citizen is used, will apply. Person includes even an alien, foreigner. Person includes. So wherever person is used, you have to understand that particular word is equally applicable not only to citizens of India but also to foreigners in India. See, inverted commas, foreigners in India, not foreigners abroad. You cannot apply to foreigners abroad. But here you have to take into meaning the consideration of a person of Indian, that is an Indian citizen living abroad. If he commits anything that is contrary to Indian Penal Code, even if it is abroad, that becomes a punishment. This is the basic procedure to be followed in the context of criminal law, substantive criminal law, Indian Penal Code. If a citizen of India living abroad commits any act which is prohibited by the Indian Penal Code, constitutes an offence. This is called, under the jurisprudence, extraterritorial application of laws. Extraterritorial application of laws. But at the same time, a foreigner cannot be booked under the Indian Penal Code. But when he is in India, he can be booked. For that distinction, Article 21, person is used. So, right to life, you all know right to life. And there is one judgment, ADM Jabalpur case. So that is an elaborate judgment on the personal life, right to protection of personal life. So there were sea changes even to some extent in the constitutional law based on the dissent opinion given by the Honorable Supreme Court of India's then Judge Justice H.R. Khanna. He is the only judge who opposed the views of other judges, even under the Constitution of India emergency situations. Right to life cannot be deprived of, come what may. Therefore, Constitution was amended to some extent and incorporated a law that right to life cannot be deprived of even during the emergency. So this why this question is raised means, as a lawyer, where a question of death penalty arises, you must be well versed with all these factors. Article 21, Article 20, Article 13, Article 22, all these come into interplay between the criminal law and the constitutional law, because constitutional law is called the law of the land. That is basic law of the land. Any other law cannot be in conflict with the constitutional law. If it is in conflict with, it is called repugnancy. You have to go through the doctrine of repugnancy to understand the conflict between law and law. What is repugnancy means? A law in conflict with another law. Criminal law amended is in conflict with constitutional law. Therefore, this is important. Now, personal liberty. What is personal liberty? So, when you come to raise the question of personal liberty, you have to understand what are your liberties. Article 19 clearly envisages all the personal freedoms and expressions. They are all liberties only. So, anything can be deprived of under Chapter 3 of the Fundamental Rights. Chapter 3 of the Fundamental Rights, preferably Article 19 of the Constitution, speaks of personal liberties in the name of freedom and expression. Freedom and expression. There are further divisions in freedom and expressions, so that I will not discuss here because this is not the constitutional law. I stop it here itself, citing Article 19 of the Constitution, and now switch over to Article 22, because Article 22 has connection to personal liberties, arrest and detention laws. Arrest laws. There are some 7 clauses, arrest and detention laws. Article 1, what it says, when arrest is made, the ground of arrest should be informed to the arrestee. Ground of arrest should be informed to the arrestee. Can anybody say which section of law in criminal procedure code deals with this Article 22 clause 1, part 1 of the Constitution? That is the article, this article has 2 aspects. Number 1, he is to be informed of the ground of selection. That is to be done within 24 hours. Okay. Section 50 of the Criminal Procedure Code is nothing but a part and parcel of Article 20 sub part 1 and Section 57 also, and Article 22 clause 1, Article 22 clause 2, in addition to informing this, his relatives and others should be informed of. So for that also, therefore, in order to understand what are the personal liberties of a citizen, when it comes to the question of application of criminal law, you have to well understand Chapter 5 of the Criminal Procedure Code from Section 41 to Section 68. These are all protections given to citizens as rights of the accused. Even if you are an accused in a criminal case, you have certain rights to be enjoyed as an accused person. Those rights of the accused are incorporated from Section 41 to 60A of the Criminal Procedure Code. More important of all these articles, that is sections, Section 60A is an incorporation into the Criminal Procedure Code subsequent to the judgment of the Honorable Supreme Court of India in D.K. Basu versus State of West Bengal. Do you know how many norms are laid down in D.K. Basu versus State of West Bengal? 11 norms. Those 11 norms took the shape of Criminal Procedure Code. This judgment is sometime in 1996 or 97 filed by the West Bengal State Legal Services Organization Chairman, Justice D.K. Basu, not Justice D.K. Basu, is a libertarian. So on his efforts that can, before this case, there is another case you have to take into consideration with regard to the arrest laws, that is Jogendra Kumar versus State of Rajasthan. Sorry, that is Uttar Pradesh, Noida state. Jogendra Kumar versus State of Uttar Pradesh. See, here it is important to understand what are the facts of the case, because police gave an evasive reply to the Honorable Supreme Court of India that we have not committed any wrong and therefore this writ petition is not maintainable. How that the court did not consider the version of the police, I will explain. It is very important. This is the fulcrum of judgments of the Honorable Supreme Court of India to sow the seeds of invasion against the abuse of police power. That is the seed germinated into law in various judgments. Milestone or landmark judgments, 3 you must bear in mind always the contents. Whenever some norms or guidelines given in a judgment had taken the shape of law, you study the law properly. Then you become a good practical lawyer. In this judgment, Jogendra Kumar was the brother of an advocate in Noida. One fine day, the police of Uttar Pradesh took away this man's brother, who is an advocate, and taken into unlawful custody. No arrest, nothing. Ravaya Podam, gone. This Jogendra Kumar had gone to the police commissioner and talked to them. He is my brother, practicing advocate. Why he is taken without any valid reason? Get out. That was the answer. You know how police people behave. So he was sent out. And he contacted the friends of his brother. What is to be done in this situation? See, one of the friends advised and filed a writ in the Honorable Supreme Court of India. What is the writ jurisdiction or original jurisdiction for the Supreme Court? Under what article a writ is to be filed directly in the Supreme Court of India? Article 32. Yes, Article 32. For that, there is another alternative method now being adopted. That is, the Supreme Court will not entertain any writ petition directly under Article 32 in matters which does not affect fundamental rights. Even if it affects fundamental rights, it directs the petitioner to approach the Constitutional Court, High Court, and then come to the Supreme Court. That is one of the procedures established by law now presently in India. Article 32 is not there. But in those circumstances, sometime in 1973 this happened. Then the Honorable Supreme Court accepted the writ petition, numbered it, gave notices to the respondents, and then respondent police came with a version that he was wanted in investigation of one of the cases. He was taken, and after investigation is completed, he was sent away, and he is not in custody. Because when writ is filed, they will send the police. You know all these tactics of police. The Supreme Court then thought whether this version can be accepted. Can the police take away any citizen in the name of investigation without showing the reason therefore, that is ground article 22 class 1, ground for arrest? Then the court did not accept that version of the respondent police. Court elaborately discussed, debated and decided the matter that the taking away of the advocate, that is otherwise called arrest. So this is not an arrest. If it is legal, we use the word arrest. It is unlawful custody. See, where the arrest is not lawful, then it is called unlawful custody. So I again use another phrase, illegal custody. Do you know the distinction between unlawful custody and illegal custody? I will explain. Court treated that even if he was taken into custody for the purpose of investigation of a case, yet without giving the ground for his arrest, it is unlawful custody. Therefore, this cannot be tolerated. This will enhance the police atrocities against the citizens and therefore it should be curbed at this stage itself. Or there the foundation of fundamental right, personal liberty, enshrined under Article 21 of the Constitution. So due procedure established by law now comes to interplay. What is the due procedure established by law for arrest that was prevailing in 1973 was examined. Thereafter, they gave some guidelines in Jogendra Kumar case. So even after that, the violations of law by police had continued. Unable to tolerate the violations of law, criminal law by the police with regard to arrest, West Bengal Legal Services Organization's Secretary or President D.K. Basu filed a public interest litigation in the Supreme Court of India, and the Supreme Court took it on record and gave 11 guidelines for the police with regard to procedure for arrest. Those 11 guidelines were for some time remained as guidelines, not being practiced. So sometime in 2005 or 2008, all these guidelines are converted into criminal procedure code. Now no more, they are guidelines, they are laws. When it comes from the judgment of the Supreme Court as a guideline, it is called judicial legislation. The Supreme Court guidelines are, if you read properly, jurisprudence, that is called judicial legislations. The Supreme Court judgments or guidelines are judicial legislations. Nobody will follow judicial legislations. If you want any example, any number of judgments can be quoted which are not being followed. Deliberately, willfully, intentionally, knowingly, people will not follow. I will go to court of law. That takes 30 years time. This fellow will be 40 or 50. By that time, this fellow will go over. Technically, petition becomes infructuous. Petition becomes, this is called delay defeats justice in jurisprudence. Delay defeats justice. We want a remedy without delay. That is the fundamentals of jurisprudence. So, D.K. Basu's guidelines are converted into law when law is not followed. What is the action? Now, to be a practical lawyer, when it comes to the guideline of the Supreme Court comes into a law, converted into a law, and a guideline remains as a guideline, what is the distinction? Anybody? Distinction. A law is enforceable in a court of law, a guideline is not enforceable. Supreme Court guidelines under Article 141 of the Constitution of India has the force of law, yet they disregard. Simply what he will say, no, my lord, I am ignorant of that judgment. I had never come across that, therefore I did not follow. I feel sorry, apathetic, that is sympathetic apology. For one simple apology, will throw away. Do you know the basic procedure of apology which came into force in the law of courts, how it came? Court will leave out. Ultimately, what is the fate of this petitioner? Nothing. For that, recently, in 2008, amendments, you know one paper called Criminology, Penology. Chadivara? Did you have in your degree course? Criminology, Penology. Is it that much only? Victimology is an emerging subject. Final year, huh? Victimology is an emerging subject. The basic criminal law and police atrocities law very, very essential. If I speak here and there some Telugu sentences, don't mind, I will speak in English also. But my mother tongue is Telugu, the urge of use of Telugu will be inbuilt in my body mechanism. So, what happens? Victimology. Now you go to theory of criminal law. What are the aims and objects of criminal law? Enforcement of punishment upon a criminal, an offender, is a state subject. It is the duty of the state to see that no person shall commit any offence. Reformative theory, retributive theory, deterrent theory, etc., etc. So many theories are there. So under that, it is the duty of the state. So one offender kills one person. The case is booked, is sent to imprisonment. What is the benefit the victim got? What is the fate of the family of the victim? They are called the rights of the victims. Do you know the word victim was not defined in 1973 Criminal Procedure Code or even before? That 1983 Criminal Procedure Code or Criminal Procedure Code 1898 did not define the word victim, but a provision of definition was inserted in the Criminal Procedure Code, I hope sometime in 2005 or 2008, I don't exactly remember that. In between these 3 years, those reforms took place. Section 2WA defines victim. So then now the procedure for protection of the rights of the victim commenced. This is a derivative from the law of torts. See, any good lawyer should not study criminal law alone. It should be studied in consonance with law of torts, because a citizen has an option for remedies either under the criminal law or under the law of torts, but not both. అర్థమైందా ఈ వాక్యము? నేను చెప్పినటువంటి వాక్యం అర్థమైందా? How many of you could understand what sentence I used? A complainant has an option for a complaint either under criminal law or under the law of torts, but not both. For recent examples, you all know pretty well Rahul Gandhi's case. కొన్ని మనకు యూస్ఫుల్ అయిన కేసులు రీసెంట్ కేసెస్ ఉంటే చెప్తాను. ఎందుకంటే అండర్ ది ప్రొఫెషనల్ ఎథిక్స్ విచ్ ఈస్ నాట్ బీయింగ్ ఫాలోడ్ ఇన్ లోయర్ కోర్ట్స్, ఐ డోంట్ వాంట్ టు టాక్ దట్. citation of an outdated law is a misconduct. Citation of an outdated law. For example, I now told you ADM Jabalpur's case. It is an outdated law, but I explained the circumstances prevailing in the emergency period. For those circumstances only I have drawn that judgment and cited H.R. Khanna, Justice H.R. Khanna, the then Judge of the Honorable Supreme Court, who was bypassed to be made the Chief Justice of India. So his dissent note. Why his dissent note is more important? One simple example is enough to cite. Justice H.R. Khanna's life-size statue is erected in the city of New York in the United States of America in recognition of his dissent note, highlighting the importance of human rights. The life of a citizen is enlivened or enlightened in that judgment. That to that particular aspect only I have brought it, though it is a bad law now. Do you know which law override this ADM Jabalpur judgment? Anybody? Puttaswamy's case, Justice Puttaswamy's case. That is a famous case which reverted the judgment of a majority bench in the ADM Jabalpur case, and the Honorable Supreme Court of India in that judgment said that privacy, right to privacy is a fundamental right guaranteed under Article 21 of the Constitution as a personal liberty. That is the reason why it is a bad law. You should not cite bad laws, even in criminal cases. I have observed in most of the advocates in the lower court, they will be citing from ALD or ALT, Asia Law Digest or something, and ALT, Asia Law Times publications, Andhra Pradesh High Court judgments. Now I raise a question that comes in the interpretation of statutes. When it comes to the question of interpretation of statutes, Article 141 says that any judgment given by the Honorable Supreme Court of India has the force of law and is to be adopted by all courts, including the high courts. Suppose this judgment had gone in appeal to the Supreme Court and this judgment is reverted, then what is the effect of this judgment? Therefore, my advice to you, to be successful practical lawyer, good practical lawyer, you do not cite as far as possible. You underline the phrase as far as possible because certain times you may not have the same situation where the issue has gone to the Supreme Court. Then it becomes final. So such judgments you have to cite Supreme Court judgments. If you have no Supreme Court judgment, then you have to cite High Court judgment of your state. If you don't find judgment of High Court judgment of your state, you adopt from the neighboring state or any other High Court. Do you know the distinction between the High Court judgment given by neighboring High Court or any other High Court or the judgment of our own court? So, authoritative precedent and persuasive precedent, jurisprudence. In that, our High Court judgment becomes an authoritative precedent, but the neighboring High Court judgment or judgment of some other High Court is only a persuasive precedent. Therefore, court may differ in its view. Hence, you should not. After arrest, D.K. Basu case, which had become law in Criminal Procedure Code in 2005 to 2008 amendments. Then comes the question of landmark judgment in Arnesh Kumar versus State of Bihar, delivered on 2nd July 2014. In this judgment, there are 8 guidelines given by the Honorable Supreme Court of India with regard to arrest matters. So now, the point for consideration is the Honorable Supreme Court of India envisaged those guidelines, taking into consideration various factors, primarily the factor of corruption, and made that judgment. Do you know the impact of the judgment? The court aimed at reduction of corruption. Do you know what is practical position? It has increased corruption. It has increased corruption. How? With my simple knowledge on the practical side, not on the theoretical side, I tell you, issue 41A notice in case of offences charged with or punishable for 7 years or less. 7 years or less. In such cases, you do not arrest the accused if he cooperates for the investigation with the police. There is no need for arrest. But just to give 41A notice, the rate is minimum 10, maximum 50,000 rupees for one accused. It has given a vested right to the police to collect that amount. Otherwise, they don't. Within how many days 41A notice is to be given? No criminal investigation procedures. You shall talk. Primarily, when British people followed the criminal procedure code, any crime which comes to the notice of police, cognizable crime, should be investigated within 24 hours time. Okay? So, having considered the practical parameters of administration of investigation that have been modified to 15 days. Subsequently, subsequently, that has been enhanced to 60 days in some cases, that is punishable with less than 10 years imprisonment, and the 90 days, and incorporated in section 167 of the Criminal Procedure Code. If it is not done, automatically if the accused is in prison, he is eligible for default bail or statutory bail. Now, crime. When crime is committed, what is a crime? Crime is a wrong against the society. It damages the interest of the society. So, all these judgments are to protect the fundamental right to personal liberty enshrined in Article 21. They are all applicable to criminal law. When somebody brings a piece of paper in the nature of a complaint, it need not necessarily deprive the proposed accused to be subjected to so much of harassment, humiliation, whatnot, everything. That is the aim of Article 21. And even 22 goes on giving so many guidelines on, these are all found, Article 29 is found in most of the sections in Criminal Procedure Code. So when we come to comparative study of criminal law and personal rights, they all will be discussed. Now, investigation. Who is an accused? We have to understand the meaning of accused. See, these words have specific meanings in which stage this particular word is used. accused. Who is an accused under the constitutional law? An accused is a person against whom an FIR is lodged. For example, wife and husband కొట్లాడుకుంటారండి at home. They have developed some disharmony for various reasons which you do not want now. But husband goes to the police station with a complaint that my husband and other relatives, these people, that people, they will leave a list of people in the complaint. They have been harassing us. But the police fellows, this is after all a family issue. Why should we take a hasty step and register the case? They ask them to come today, tomorrow, day after, 1 week after, 2 weeks after, like that, 1 or 2 months they revolve around. Does he become accused? No. FIR is not lodged. Unless and until an FIR is lodged against a person, he will not become an accused. The moment FIR is lodged against a person on the basis of a complaint in a cognizable offence under section 154 class 1 criminal procedure code, then only he becomes an accused. Okay, క్రిమినల్ లాలో అక్యూజ్డ్ అన్న పదాన్ని మనం ఏ స్టేజ్లో ఎప్పుడెప్పుడు వాడవలేము, when, how, at what stage the change of phrase or word should be done, should be clearly maintained in criminal law. An accused is a person against whom a first information report is lodged. So if there is no FIR, there is no accused. He is not an accused. An accused is likely to become an under trial. Under trial. What does it mean under trial? He may be in prison or outside the prison. He is only in under trial. So, under trials in custody, under trials on bail, second stage. Then the question of application for bail. When it comes to the question of application for bail, all these 3 judgments which I cited earlier, Jogendra Kumar versus State of Uttar Pradesh, D.K. Basu versus State of West Bengal, and Arnesh Kumar versus State of Bihar. These 3 judgments play a dominant role in the discussion of a bail petition. Bail petitions, jurisdiction, sections of law, 436, 437, 438, 439. Do you know what are the distinctions? And in another bail petition also can be filed 167. 167 statutory bail or default bail. So that is also a possibility there. And this is with regard to only general law and special law, special criminal laws. What are they? So put a National Investigation Agency Act, Unlawful Activities Prevention Act, Narcotic Drugs and Psychotropic Substances Act, Food Safety and Standards Act, Drugs and Cosmetics Act. All these deal with offences. So how do you distinguish whether an offence booked under special law is a bailable offence or a non-bailable offence, is a cognizable offence or a non-cognizable? Because certain times those laws will not deal with general principles. మనం జనరల్ లా మాత్రమే కన్ఫైన్ అవుతాం ఈ లెక్చర్. ఇన్ దిస్ లెక్చర్ ఐ కన్ఫైన్ ఓన్లీ టు ద జనరల్ లా అండర్ ది ఇండియన్ పీనల్ కోడ్, క్రిమినల్ ప్రొసీజర్ కోడ్ అండ్ ఇండియన్ ఎవిడెన్స్ యాక్ట్. When an FIR, when you read criminal procedure code, you have to make your study a topsy-turvy. First you study section 154 to 176. Then you have to study section 41 to 68. procedure for lodging FIR. There you have to distinguish cognizable offence and non-cognizable offence. Number 2, bailable offence and non-bailable offence. Number 3, compoundable and uncompoundable offence. These 3 are very important factors when you deal with a criminal case at the lowest level and on withdrawal of complaints. These procedures. Because compoundable or non-compoundable offences, how do you know? Where do you find the table on compoundable or non-compoundable offences? Section 320 Criminal Procedure Code deals with the table of offences in 2 categories: compoundable and non-compoundable offences. Offences compoundable with the permission of the court, offences compoundable even without the permission of the court. There are 2 tables. They are the guiding principles for the criminal lawyer to say that the offence is compoundable. Outside the court, the people will settle. Outside the court, people will settle ani eppudu cheppala. When can you say that? In case of offences compoundable even without the permission of the court, you can say that the offence will be compounded outside the court, but you cannot say that in case of offences compoundable with the permission of the court. The Honourable Court may permit me to settle the issue with the permission of this Honourable Court. That should be your pleadings. Okay. Section 320. 154. Class 1. Criminal Procedure Code Prakaram, when a complaint is not received and registered under section 154 class 1 of the Criminal Procedure Code by the station house officer of the police station falling under the jurisdiction of the police station, that is complaint given by a complainant falling under the jurisdiction of the police station, if the complaint is not accepted or registered by the police officer, station house officer, then what is the procedure to be followed? That is, you have to apply section 154 class 3 of Criminal Procedure Code to send the very same complaint to the superintendent of police of the district concerned. That is, rights of the complainant, that is the victim, and police investigation. Crime had happened, police did not register the case, even at the insistence of the complainant. Then what is the remedy? You write to superintendent of police. See, practical lawyering. ఏం చెప్తుందంటే సూపరింటెండెంట్ ఆఫ్ పోలీస్ ప్రతి స్టేషన్ వాళ్ళు కవర్స్ ఇస్తారు, అందువల్ల సైన్ అండ్ ఫైన్. ద రీజన్ ఫర్ దట్ ఈస్ innate, inherent, not looked by the people. So they don't take action. Then what is to be done? Next course of action is that you have to write a complaint to the higher-ups of the superintendent of police under section 36 of the Criminal Procedure Code. Section 36 of the Criminal Procedure Code ప్రకారము DIG, Inspector General of Police, Director General of Police, Home Secretary వాళ్ళందరికీ పంపించవచ్చు. Victims' rights, investigation failure, victims' rights. Then they also do not take action. You have some other remedies. 8 stages I brought these only 3 stages, and the next stages I will not explain because they are optional stages. మనకు ఇష్టం ఉంటే ఆ స్టేజెస్ ఎగ్జాస్ట్ చేయొచ్చు, లేకపోతే లేదు. ఎందుకంటే ప్రొసీజర్ ఆఫ్ కంప్లైంట్లో when once you lodge a complaint to some higher up, you have to wait for 3 to 6 months time to avoid lapse of time, delay defeats justice, and witnesses may die, evidence may disappear, all these things happen. So you have to lodge a complaint, 200 private complaint. Then criminal law is set in motion. Here we have to understand section 154 only deals with the offence, cognizable offences only. For section non-cognizable offences, 155 procedure will be there. What is the procedure to be followed by non-cognizable offence? First of all, let us understand the meaning of cognizable offence. What is a cognizable offence? Cognizable offence is an offence which can be registered by the police officer and take up investigation without the permission of the court. They need not take the permission of the court of law, of the jurisdiction concerned. They can issue FIR, they can start investigation, and they can arrest the accused and investigate the case, process of investigation. Cognizable offence. But what is the procedure for non-cognizable offence? A police officer cannot issue an FIR in case of a non-cognizable offence. He cannot take up investigation on his own without the permission of the court. He cannot file the charge sheet before the court in a non-cognizable offence unless and until the honorable court concerned permit the police to register the case, that is, investigate the non-cognizable offence. Recently, one issue has come up to that level, wherein electoral offences have been committed, some people, under section 31, that is non-cognizable offence. Police did not take permission because of the pressure of the state government. Police issued FIRs that had now become, that is, gallows to the police. Election Commission took up all those cases. So such things should not be committed. When that such things are being committed, as a good practical lawyer, you have to raise that question at the very beginning when the FIR is issued against the accused, and this court ought to have not accepted the FIR. FIR should not be accepted by the court when it is on a non-cognizable offence. Number 2, police investigations and filing of the charge sheet. Police have a role from the time of registration of the offence till the filing of the charge sheet under section 173 class 2 of the Criminal Procedure Code. Thereafter, the role of court commences. Thereafter, the role of court commences to conduct inquiries if necessary and trial. Even without trial, in some cases, accused can be discharged for some reasons. Investigation methods fail you. I tell you one example. Suppose one public servant is there, one person, that is one police officer, filed the charge sheet against a public servant that in the court of discharge of our duties, this public servant committed the offence of 353 against us police officers who are discharging our duties. Can the court take on to file such a charge sheet when it is lodged against the public servant? No. There is a parameter. Lapses in investigation అన్న విషయాన్ని నేను మీకు ఎందుకు చెప్తున్నా అంటే jurisprudence procedural law ప్రకారము as per jurisprudence and procedural law any fundamentals that is called primaries should be raised at the early stages of the litigation or trial or anything whatever you call, but not at the stage of appeal or revision. But not at the stage of appeal. So the appeal or litigation will examine whether the punishment given is correct or not otherwise. At the appeal stage, some of the lacuna may be filled up, but at the revision stage, even if there are lacuna, whether it is the failure of the counsel for the accused or whether it is the failure of the state represented by the public prosecutor, they cannot be taken into consideration unless there is gross injustice done to the accused. What is that gross injustice? Suppose some revenue officer is there or some school teacher goes on election duty and says something. Suppose elementary school teacher is there or some school assistant is there as a presiding officer of the polling booth. Then this police officer, when he says you should not do that, he will lodge a complaint because FIR is within his hands. He will lodge an FIR, section 353, obstructed me from the discharge of my duties. Can it be accepted? No. Methods of investigation, failure of investigation agency, what investigation? So 197 procedures. Now coming to the point of investigation by the police after registration of the first information of report or permission obtained by the police for registration of a non-cognizable and further investigation. Here comes the question. Investigation. What is to be done by a police officer in the course of investigation? How to muster evidence, the gathering of evidence. Evidence, how many types? I talk evidence of only general law, not special law. When the question of special law comes, it goes to some other agencies, not the civil police. No, okay, sir. Why not? Now it has come to a stage where investigation. Okay, much nice. Let us have a pause for about 10 minutes, and after that I will start investigation, evidence, adducing evidence.
Thank you, my dear students. Now, real investigation starts after break. So, 10 to 15 minutes gap will give you. You can have water or something, and we will assemble after 15 minutes. Thank you.
So be quiet. Excuse me. The last persons. See, we already told you regarding the moot court competition. And today is the last day to submit your registration. By today evening 3 o'clock, we will close the registration. If anyone who are not having a team, you can come and directly give your name. So if anyone interested, Principal sir, now or afternoon? So before 4 o'clock evening, you can give your name. Registration? already we sent the registration link. In that you need to register your name, that means your register number, which course you are doing along with your participants. Suppose if you are not having a participant, that means a team, you can individually come to us and you can register your name. These people didn't give the name. Endilla, team illa. If you want to take victimology class, take. I am going. They are not interested, sir. Only reading, sir. And it is not T20. Not even 20 is not there. Okay. Till now they created
60.
Yes, Mr. Sharma. We need to create a team. You ask someone else, you encourage. You ask who are interested, individual.
I put a note higher and drop it to every call.
That is your
Since they are saying that every detail is against me, they are unable to do it.
who tell me, find out, tell me your fact, give me your fact. Just will include. Tell me who are they telling.
Who said no to me? But many sir, they are already. You want the telling names is I think not.
What about search and not ready?
Dear students, Mr. Sharma is a regular student. What he is telling, you will be surprised to know. He is telling, I am ready, but no one is ready to submit their name along with me. No one is ready to. Is anyone ready? Kindly give your name. He is a good student actually. But I am telling you, he is a good student. He is interested but what he will do when his friends are not ready to extend their helping hand. Today also before 5, the last date of submission of your team name. Today is the last date. Before 4 or 5, kindly submit your name to Julie Madam or our Panda sir. And already the Honorable Chairman sir already announced the cash prize, 10,000 prize is there. Money, forget about your money, you will get that. But about, I will tell you, when you will participate, your evaluation of papers, internal papers, Viva time also, you will get good marks. As a principal, I assure you. You will participate, then definitely you will get good marks in Viva. your marks will be awarded accordingly. And you will learn. You will learn so many things there. How to present before the court, before leaving. Before leaving, you will learn so many things. Because we are going to invite the retired judges for Moot court. So you will learn and you will witness that program. So kindly come forward and participate. I am inviting you and encouraging you. That doesn't mean we have team. We have already 20 teams are there. I am telling you. But I am encouraging you. It's part of my work. So come forward. Okay, please come forward and give your name.
Can I tell something? See, everyone please listen. Please listen. Here Principal Sir was telling you regarding the Moot court competition. See, near to 1,300 students are doing your final year Ll.B. here. Near to 1,200 law aspirants are sitting in front of us. Majority of you are not regular to college. Yes, we are accepting that. But the thing is like when you are going for your higher studies, so many times we clearly told you this is the platform where you are molding as advocates. If you fail in the competition, if you won in the competition, that is secondary actually. That is secondary. You participated in Moot court competition. All colleges, when you go for your LLM, just listen. For those at least who thinks about your future, please listen. When you go for your higher studies, they will surely ask you to show your achievements. That means certificates. If you are having mark statements, first year, second year, third year, up to final year, 3-year or 5-year course, you need to keep your Moot court achievement certificates with you. That now you will not understand. Once you complete, once you join for your LLM somewhere, if you come here to get your Moot court certificates at that time, it's difficult for you to issue from the college. That only we can tell you.
Madam will address about this one. Kindly tell them the name of professional things, how to write this materials.
Okay, so hereafter please listen clearly. Danya madam is going to discuss here regarding the 3 records. At least give attention to that. The 3 records which is important for your Viva part. She is going to explain you.
Good afternoon. Good afternoon, everyone. Side writing la. Bear with us for 45 minutes also. So, as per part of your academics, they will be given 3 record books. You will be given 3 record books. That is one with regard to ADR, another with regard to drafting, pleading, conveyancing, another one with regard to your Moot court, pre-trial preparations, participations in trial proceedings. Okay. நீங்க ஒன்னும் கவலைப்படாங்க, இது எல்லாம் prepared-ஆ இருக்கு. Only thing is, you will be supplied with materials. For all the 3 records, 3 records would be given and 3 materials also would be given respectively. Now last day there was some confusion how to write the records and all, so I will be explaining each one. It's simple, please pay attention. Please don't come ask other faculties இது என்ன கேட்காதீங்க. தெரிஞ்சவங்க மத்தவங்க ஹெல்ப் பண்ணுங்க. கொஞ்சம் கவனமா கேட்டுக்கோங்க. First one is with regard to alternate dispute resolution, this ADR. Materials would be given to you. Now there would be a certificate page. In that certificate page you have to write your course, which course you belong to, which academic year it was, and your registration number, and it will be signed by the principal sir and lecturer in charge. That is by the time before you come for Viva. Viva ku varra munnadi neenga idella complete pannittu varano. The next thing is you have to number everything, border ella irukku. Assignment or answer sheet madri colorful ஆன எழுத தேவையில்லை. Just use blue or black. That's more than enough. அதுல நீங்க reading border எல்லாம் நீங்களே போட தேவையில்லை. It's already border is there. You have to first do is number all the pages. page number பண்ணுங்க. In the material that has been given to you, there is also an index and how it has to be filled, in which order you have to write it. That is also being mentioned. Like for example, negotiation la first part is negotiation, conciliation, arbitration and case study or role play. Material is being supplied to you. இதே அப்படி நீங்க bookலே எழுதணும். You have to write the serial number and once you write inside also you have to write the serial number, the date, particular date இங்க prescribe பண்ணிருப்பாங்க. இந்த date தான் எழுதணும். Confusion தேவையில்லை. இதுல date இருக்கு. அந்த date தான் நீங்க எழுதணும். Then correct order. What essential ingredients of negotiation, steps of negotiation, whatever it is, and the page number. Each thing have like all pages have to be numbered and both sides எழுதலாம். Okay. Now those who have bigger handwriting, so கொஞ்சம் சுருக்கி எழுதுங்க, சின்னதா எழுதுங்க, so that you have to fill everything. Okay. This is with regard to ADR. Now drafting, pleading, conveyancing. It is around 83 pages. 83 pages. That also goes the same way. Drafting, first 10 parts would be civil, next 6 parts would be criminal. That is also index la உங்களுக்கு தேவையா, like it has been printed. அது print பண்ணி வந்திருக்கு. So you only have to do is write what is given in the material in the record and number the page. Corresponding number had to be mentioned here. Okay, and this also had to be signed by the principal sir as well as the lecturer in charge of drafting pleading conveyancing. Okay, now இப்போ plain எழுதி முடிச்சிட்டோம், மீதி பேஜ் இருக்கு எழுதணுமான்னு கேட்டாங்கன்னா உங்களுக்கு பேஜ், if it's not sufficient for you, continue writing. If it is not, start writing from a fresh page. Okay, don't எல்லாம் கூட ஜாம் பண்ணி எழுதாதீங்க. That's also, please don't use another color of ink or anything, either blue or black. Don't write anything. Now next part would be moot code. Moot code and already 3 moot code problems is being given to you. That materials also will be supplied to you. And first moot code la petitioner or the plaintiff side, we have solved the moot. We have given you the problem, but moot has been solved. And I think Robert would be familiar with the first moot. Then the first moot with regard to the petitioner side. Okay, other petitioner side every moot எழுதணும் சொல்லி சின்னதா crux-ல கொடுத்திருக்கோம். Next is with regard to the respondent, another moot problem. That would be another moot problem, but emphasis is given for the respondent side. And the third moot problem would be given to you and judgment, how to write the judgment. Because many of you might have the you want to pursue JCJ, so how you wanted to address, how you wanted to write. How you want to write the judgment, every material is also there. So 3 moots you have to write. First would be with regard to the petitioner side, second with regard to the plaintiff side, respondent side, and third would be with regard to the how to write a judgment. Clear? Now that's what the first part. Adukapram the book would be separated, then you have to write the court observances. Okay, how you have to write the court observances, and here also you have to write the page number and equivalent. Why this is important is because during Viva, inga irundhu enga vela ungalku question varala, from anywhere you will put questions with this record. So don't try to skip any part. Idu skip panna, if it is found in the notice of any faculty, then your marks will be affected. So write everything what has been given in the material and make sure you number the page and write on both sides and do this before, once they give you the materials, start writing because you will not get much time. 3 materials are there you have to write. So complete it before you have to present for the Viva. So is it clear here? Any further queries? So thank you so much and now sir, I welcome sir. Oh sir. Thank you guys.
He will come on. Silent please. The last bar, please don't turn the AC. The outlet water pipe will be cut off. Don't touch that AC. Wait, he will come on the switch on.
అన్నీ ఓపెన్ చేయండి. హలో
Okay, yes. Dear students, our guest today was delivering lecture on crime and crime investigation, referring very important articles connected with the criminal law, constitutional law, criminal law, what are all connected articles and sections, right? Especially Article 21, referring to right to life and personal liberty. Now this Article 21 is being widened like anything by the Honorable Supreme Court. Even the living relationship also comes under right to privacy. Right to privacy, it is not an offense now. But now the present government is going to pass legislation, I think it is pending for assent. And all the living relationships, they should get registered. And you know the consequences of it. The institution of marriage will certainly be broken. So now, right to life and personal liberty is so widened. Of course, giving a top priority for individual rights, freedom. This is called freedom. As you know very well, too much freedom is also very dangerous in the life. Even to themselves also. Right? So now, we are asking always freedom and rights. Do anyone asking for duties? Nobody is asking for duties. Or nobody is interested to perform their duties. We bother about our rights and our personal liberty. Of course, certainly it should be given top priority. But at the same time, these rights and duties should go together. Then only the society will function in a better way, right? So now I request our Secretary Karu, today's guest, to continue the lecture of this now. Thank you.
Dear students, our sir had raised a very good issue, that is living in relationships. It is not new to our Indian society now. It had been predicted by the Britishers in the year 1872 when the Indian Evidence Act was framed. But our Indians are not conscious of that particular section in the Indian Evidence Act, which recognized living in relationship in the nature of a marriage. Living in relationship in the nature of a marriage is a phrase used in the Domestic Violence Act. And for your information, I should not make the young generation go astray in life and do all these activities. Honorable Supreme Court of India said that this particular issue is an issue of morality, not a legal issue. Number 1 point. The Honorable High Court of Bihar has awarded maintenance in case of living in relationship in the nature of marriage. That living in relationship in the nature of marriage has been incorporated in section 50 of the Indian Evidence Act. We, the people of India, have not become conscious to the concept of living in relationship as incorporated by Sir Stephen Fitzgerald, the author of the Indian Evidence Act. The author of the Indian Evidence Act is Sir Stephen Fitzgerald. He had already predicted that there will be this concept in Britain. They called it as an inferior type of marriage. What is a marriage? Meaning of marriage? Meaning of marriage. Most of the people do not know. In Benediction Forbidding Mourning by John Donne, a metaphysical poet, what he says, marriage is a union of souls. Physical union is no union, but mental union is a union. Souls should unite. He had given the example of a mathematical compass in between the couple. The Benediction Forbidding Mourning అనేది సెకండరీ పిఎల్లో చదివాను పోయిటరీ అప్పుడే నేను నేర్చుకున్నా ది ఇంపార్టెన్స్ ఆఫ్ మ్యారేజ్ అని. సో ఇట్ ఈస్ ఎ యూనియన్ ఆఫ్ సోల్స్. ఇన్ మై ఒపీనియన్ in that family court, instead of conducting there, if it is conducted here and some cinema songs are displayed, what is union of souls will be understood by these couples who always cockfight for no reasons, valid reasons, even though there are children whose fate will be spoiled by reason of this disharmony. It should be a union of souls that is already recognized, and I will leave apart that particular topic. Now, coming to the chapter on police investigations. So, I already told you what is a cognizable offence, what is not a cognizable offence. It is relevant to understand the importance of a cognizable offence in the context of investigation. The police have power to take up investigation without the permission of the court only in cognizable offences. In non-cognizable offences, without the permission of the Honorable Court, the police have no right to commence investigation, have no right to issue first information report, and therefore first part of investigation on police role deals with cognizable offences. We have to first know what is the classification of offence, that is trifurcation of offences under the Indian Penal Code. Trifurcation. What is trifurcation? Bifurcation, state bifurcation. Bi means divided into two. Tri means divided into three. So under the Indian Penal Code, when it was basically framed by the Britishers in 1860, they had trifurcated the offences in the Indian Penal Code into three categories. Number 1, petty offences. Number 2, serious offences. Number 3, heinous crimes, heinous offences. So in recent times, within a period of 1 decade, the Honorable Supreme Court of India felt that there is a need for creation of another class of offence called grave offences. So first, I explained what is a petty offence, what is a serious offence, what is a grave offence, what is a heinous crime, in order to understand the role of police with regard to investigation of cases and the role of judiciary to enlarge the accused on bail. When the question of issue of FIR against a person is raised, when he becomes an accused for the reason being registration of an FIR, automatically the question of cooperation with the investigation follows, and investigation right confers the police to call the accused to police station for the purpose of investigation. They do mostly orally, not to create any record, to raise any misconduct against the police. Misconduct of the police in the course of investigation is an important part of an advocate's ability to pinpoint even in the court of law. For example, some Tirunelveli case is there in COVID time. Some two people, father and son, were killed. Tamilians will be better knowing about that. Professor Chandu, the judge of the Honorable High Court of Madras, had been appointed as an inquiry officer. He held the police as well as the court magistrate, but not the prison department, responsible for the killing of those people. You all might be knowing the infamous case of Professor Stanswami. Christians might be knowing. Otherwise, in my opinion, they should know better about Mr. Stanswami, who passed away while in custody. So, cognizable offence registration, what are the rights of the accused? When FIR is lodged, the rights of the accused, he does not surrender all the rights to the state, that is police, the moment an FIR is registered. Yet he has his own rights. So what are those rights? Just first right, protection from arrest. Protection, that is freedom. Personal liberty, I explained Article 21. So he does not totally lose the personal liberty ensured under Article 21 of the Constitution just because an FIR is lodged. Even though there is an FIR, his rights are enumerated under Article 22 of the Constitution, and these rights are incorporated in the Criminal Procedure Code and here and there in the Indian Evidence Act also. Therefore, what are they? Now comes to question of bail. I told you non-bailable offences and bailable offences. Cognizable offences, non-cognizable offences. So I told you grave offences, which are grave offences, which are heinous crimes, which are serious offences, which are petty offences. Do you know what are the differences, all these categorization? One, section 206 of the Criminal Procedure Code envisages that any offence punishable under below 1 year of imprisonment, simple imprisonment, and fine only, that constitutes a petty offence. That constitutes petty offence. My dear students, you should know the reason between cognizable offence and the petty offence. A petty offence may be a cognizable offence, but yet the right to bail is based on these classifications. In petty offences, 99.9% cases, the bail is a right but not an exception. Bail is a, that Sunil Batra versus State of Rajasthan case delivered by Honorable Justice V.R. Krishna Iyer. He laid down a principle that in all petty cases, not only petty cases, with regard to bail, right, bail is a right, not jail is an exception. That principle is directly applicable in case of, I cite one example, cognizable but petty. In COVID time, the municipal authorities gave a direction that all people should not roam about in the streets, especially without masks. If any police fellow says that why have you come here and roaming about, there should be a reason. if you don't show reason, identity, etc., you fulfill the question raised by that fellow, automatically you are likely to be booked under section 188 APC, punishable with only 1 month imprisonment and fine of 1,000 or something, small fine. And it is a cognizable offence. So for classification of cognizable offence, the question of petty offence or serious offence or grave offence or heinous crime is not a link. Quantum of punishment is not linked to the classification of offence as either cognizable or non-cognizable. For example, I tell you, if any offence is incorporated in the Indian Penal Code, which is directly applied to the public servants, mostly the legislators, that is Parliament, or even the British people, classify it as only non-cognizable offence. It is only to protect the interest of the servants of the state. To protect the interest of the servants of the state. Even many of the advocates also do not know why this classification is done like this. For example, I tell you one section in the Indian Penal Code 166A, any public servant working under the law, against the directions of law, is to be booked. Suppose one girl goes to the police station, example, one girl goes to the police station. Do you know a veterinary doctor, Hyderabad case? Some name Nisha, veterinary doctor, I don't know them, sir. Some name is given, Nisha or something, I don't know. These people, Disha police station started. In that case, that girl is given another name that I forgot. So, when that girl went to the police station and gave a police complaint about threat to her life, the police fellow did not take any care. Within hours, she lost her life. Within hours, she lost her life. Then this question raised, at the public servant who did not discharge his duties in accordance with the law had not been taken. Okay. Live examples. That is best example. Why? Because it is 166A, they have not made a cognizable offence. That is, flaws in the lawmaking. Flaws in the lawmaking to protect the interest of the state. That is the intellectual dishonesty. So there you can, if you go through deep into the international law and the law of some other countries, you can understand what are the defects in our laws. Foreign textbooks, if you go through, some people laugh at us. My own brother laughed at me when I studied hands-on Contract Act and other laws pertaining to Britain. Why you should go through foreign textbooks even if there they don't discuss the Indian laws act. It is important to understand the legislations which are imperfect, legislations which are perfect. You can classify that. I tell you one best example which is there in the British society and which is not here, investigation purpose. Petty larceny అనేది ఇండియన్ పీనల్ కోడ్లో లేదండి అఫెన్స్గా. Petty larceny, you all would not have heard of this phrase, petty larceny. Petty larceny is a small theft, a negligible theft, may be done due to a factor of excessive loving, that is mental attitude. So that is negligible value. Such thing British people made a petty larceny as an offence, not to be seriously taken care of. But in Indian society, IPC, minimum 379 theft. Theft is defined in 378 and theft is punishable under 379, and classification of offences are relating to theft, extortion robbery, dacoity, graded system of offences. In this graded system of offences, our Indian society, that is Indian Penal Code, does not have petty larceny as an offence. For this purpose, we have to go through foreign textbooks to know the standards of psychological factors incorporated into the. దీనికి ఒక ఎగ్జాంపుల్ ఉంది, మళ్ళీ నేను చెప్తే అది అరగంట అవుతుంది, వేస్ట్ టైము, అది దానికి too much time will be required. So petty offences are no moderation, even on bail. For petty offences, mostly they will be bailable, and for bailable offences, when FIR is the first issue that comes to the rescue of an accused in order to protect his rights, his right to bail. Right to bail. 436 bailable offences, 437 non-bailable offences, 438. ఎక్కడైనా పుస్తకాల్లో యాంటిసిపేటెడ్ బెయిల్ అన్న పదం ఉందా? మన గైడ్స్ లో తప్ప. It is not to be called as anticipated bail in strict terms of the law commission. It is a bail in apprehension of arrest. Section 438 క్రిమినల్ ప్రొసీజర్ కోడ్ కన్నా చూస్తే లేదు, లా కమిషన్ రికమెండేషన్స్ చేసే నో వేర్ ఇన్ ద వరల్డ్ యాంటిసిపేటరీ బెయిల్ ఈజ్ యూజ్డ్, బట్ కలెక్టివ్లీ అవర్ పీపుల్ ఇన్ యాంటిసిపేషన్ దే టేక్ బెయిల్, therefore they use it as anticipatory bail, but you don't use that phrase in your drafts for bail. In your drafts for bail, you simply say the accused has filed this application for bail in apprehension of arrest in crime number so and so of so police station, crime number so and so dated so of so police station under section so of the Indian Penal Code. You should write in apprehension of arrest. And 439 is a revision petition for bail if the accused is already in custody, to seek that the lower court had erred in law to keep him in custody, and therefore this honorable court may be pleased to release the accused on bail, correcting the error committed by the lower court. That is the aim and object of section 439. 436, 437, 438, 439 అర్థమైంది కదా? దీంట్లో క్లాసిఫికేషన్ ఆఫ్ అఫెన్సెస్ అప్లై అవుతుంది. 436 is a very simple bail application. 437, in the same court you can file, but when the offence punishable is more than 1 year, up to 3 years, one procedure, up to 7 years, another procedure, up to 10 years, different procedure, and more than 10 years imprisonment, they are heinous crimes. The directions of the Honorable Supreme Court of India and the provisions incorporated under section 437 or 439 are such that whenever the court grants bail in offences punishable with more than 10 years of imprisonment or life imprisonment or death penalty, the court should be doubly cautious to grant bail. Doubly cautious means as far as possible to keep them in custody. The simple reason is psychology and criminology. Psychologically he may be prone to commit offences of this type if released on bail. That is why there are restrictions whenever one is booked under, and in your bail application also. I don't know whether in the chapter drafting, pleadings and conveyancing that stage has come or not. In your bail applications, whenever you file a bail petition under section 438 or 439 for grant of a bail in case of offences punishable with 10 years or more or imprisonment for life or death penalty, you have to make a declaration that the offences registered against the accused herein are not punishable either with imprisonment for more than 10 years or imprisonment for life or death penalty. It is a precondition in the bill of, if you don't write it, they may raise a query and return it. Okay? Drafting, pleadings and conveyancing, you should write specifically in case of offences punishable with 10 years of imprisonment or more, or life imprisonment, or death penalty. ఈ సిచ్యువేషన్ in practical life, one place it has arisen. Can you cite, anybody can cite as a liberty to quote very famous accused, ex-chief minister of Andhra Pradesh. 409 section was incorporated. The police fountains, investigation process. In the investigation process, police play foul to put the accused in critical condition. ICCU antaru. ICCU ante telusu kada? Intensive coronary care unit. ICU is different from intensive care unit. Intensive coronary care unit is different. So these police fellows, what you do now, instead of putting the accused in intensive care unit, they put the patient in intensive coronary care unit. అక్కడ ఏంటంటే ఇంటెన్సివ్ కరోనరీ కేర్ యూనిట్లో పెడితే రోజు 40,000 బెడ్ ఛార్జెస్ అవుతుంది మామూలు హాస్పిటల్లో. మామూలు దాంట్లో 10,000 అయిపోతుంది. అందుకనే సిద్ధార్థ లూత్రా హ్యాస్ కమ్ ఫ్రమ్ ఢిల్లీ, మిస్టర్ సిద్ధార్థ లూత్రా. So they found flame. You must be able to pick up that found game. Investigation process లో జరిగే పనులు ఇవన్నీ. So this is with regard to heinous crimes and bail. First issue that comes to the neck of the accused is whether I should be behind bars or outside the bars. So to overcome that issue, you should pick up loopholes in the investigation process, loopholes in the registration. Police fellows, usually what they do is, non-cognizable offence might have been committed, they pick up one cognizable offence from the Indian Penal Code connected to this particular issue to say that I have power. In the criminal law, I don't exactly remember the section of law, subsection 155 class 5 what it says is, if one cognizable offence is there in the FIR, even though there are all many non-cognizable offences, police has the power to register the FIR and investigate all the offences. So one cognizable offences will be added along with non-cognizable. Abuse of power, police power. Generally, academicians doing lectures do not come to the practical parameters of criminal law application, and therefore what judges or other high officials, dignitaries think is that police are good. Police foul place can be understood only by a criminal advocate who has sound knowledge of rights and duties, rights of the accused and the duties of investigators. Those two go parallelly like a double bullock cart. If one bull walks slow and another bull goes speed, the cart will not go forward. Like that, you must be able to pick up. In case of heinous crimes, I told you. Next comes to grievous offences, grave offences. Grave offences are those which are punishable with more than 3 years or even 7 years above, up to 10 years. That classification grave offences, for that grave factor comes Arnesh Kumar versus State of Bihar. Do you know why I told you all these three cases even before I started investigation chapter? Unless and until you understand the constitutional rights as guaranteed in Article 20, 21, 22, as in application of the definition given in Article 13, you cannot pick out the loopholes of investigation. So, now, if the offence is punishable with more than 7 years imprisonment, again, there is a problem only. But a new law had been laid down by the Honorable Supreme Court of India in Ornesh Kumar v. State of Bihar, giving 8 guidelines to be applied by the police when an FIR is lodged against an accused in order to grant bail. Courts should not be flooded with bail applications and take away the precious time of the honorable courts for silly reasons. There is a strong reason for this also, why this decision is taken. In 85 to 90% of the cases registered by the police on offences punishable with 7 years or less, there are acquittals. When lastly the accused is likely to be acquitted, why should he be incarcerated? జైల్లో పెట్టాల్సిన అవసరం ఏముంది? అక్విటల్ అయిపోయినాడు. మీ క్రిమినల్ లాలో కాంపెన్సేటరీ ప్రొవిజన్ లేదు, రాంగ్ ఇంప్రిజన్మెంట్ ఉన్నదా? See, some people, legislators raised a question, you put us behind bars for any number of years. When ultimately I am acquitted, you compensate for the income I lost, the prestige I lost, the obloquy and dishonor you brought by your system of criminal law in the society. That question was raised and Parliament could not decide that factor. This is the reason why you should go and read international level books. I have to some extent gone through Professor Sutherland's criminology and penology, which is not mostly studied even postgraduate level in this. That is why I say this. See, I am unnecessarily incarcerated by reason of registration of the first information by found gain of the police for a quid pro quo. For a quid pro quo exchange. You did some favor, that fellow did some favor, which everybody knows what is that favor. So for that I need not be behind bars. When this way contention is raised, in 85% of the 498 cases, acquittals were there, and families were not nominated, and cousins were implicated. In 498 case, taking into consideration all these factors, the Honorable Supreme Court framed guidelines not to arrest accused when offence is punishable with only 7 years or less. Just issue 41-year notice. He has been bound over, accused is bound over. He had come to the notice of a registration. He has to cooperate with the investigation agency and the court. That is enough. Now the other side, flip side of the coin is that has also, they have police fellows fixed the rate to give 41-year notice. Now after bail, investigation process. Investigation process includes mustering of evidence. Mustering of evidence ante to prove the offence, what all the evidences are available to be procured by the investigation agency. Number one, there are about, in general criminal law only I talk about, not special criminal law. Special criminal law carries additional material like scientific aids to investigation, that I don't discuss here. In general criminal law, oral evidence, documentary evidence, confessional statements, dying declarations, physical evidence, expert evidence, all these are taken. Number one, oral evidence. Oral evidence, you have to follow two simple factors. Oral evidence is adduced under the Indian Evidence Act section 58 and 59. A fact admitted need not be proved. A fact admitted need not be proved. When once the accused admitted a fact, it need not be proved. Why that admission? Then a question comes, why he is admitted? It should be before court of law. Here, that is, I told you 6 items. Seventh item, that is, seventh item is simply, in addition to admission, it should be before court of law. An admission before court of law is called a judicial confession. A judicial confession. Then comes opposite, extrajudicial confessions. Extrajudicial confessions. Now, in the course of mastering oral evidence, I told you one is oral evidence. For recording oral evidence, what the police do? They give notice under section 160 as a witness, some of the witnesses, 161 recording the statements of the witnesses, 162 recording the statements of people available at the scene of evidence or its surroundings, that is under the physical evidence of material objects. So neighbors will be examined. After examining them, all this will be filed before the court. Then the question of contradictions and everything will arise in the court at the time of cross-examination. We don't go, this investigation will be discussed up to the stage of filing of the charge sheet by the prosecution agency only, not beyond that. Section 178 clause 2, as per that, the police after investigation file the charge sheet against the accused. If they don't find any evidence or if the evidence is deficient, they have to file the closure report under section 169 of the Criminal Procedure Code. Mostly without heavy kickbacks, this will not be done. Generally, that will not happen, even if accused is innocent. Number 2, documentary evidence. See, in the classification of offences, when you go through, some offences will have only the importance of oral evidence. Documents will not be of any use or much use. In such circumstances, the primacy of place for evidence mustered by the police will be there only for oral evidence. In some cases, documentary evidence plays much role. And there is one principle in the Indian Evidence Act. Oral evidence does not exclude documentary evidence. For example, some offences are there, 400, thereafter you will get all property offences. Property offences. See, in property offences, documents do play a dominant role rather than the oral evidence. The principle is, oral evidence does not exclude documentary evidence, and the evidentiary value of a document is decided on various factors envisaged in the Indian Evidence Act section 90 to 99. Here classification of documents are two types in this particular area, 90 to 99. non-descriptive documents and descriptive documents. Descriptive documents, they give more details about the transaction, more details about the non-descriptive discusses the particular points of legal position. So non-descriptive documents envisage the authority upon the accused to prove his innocence. So after this comes physical evidence. You know, document evidence, register office record is there, electricity bill is there, and MRO office record is there, and several other matters, tap connection papers are there. All these documents proved. But at the scene of offence, physical factors such as length of the place, width of the place, environment of the place, that is in police terms called scene of offence. Scene of offence, physical evidence, otherwise called material objects available at the scene of offence. Material objects available at the scene of offence. So, number one, oral evidence. Number two, documentary evidence. Number three, confessional statements. Confessional statements recorded under section 161, 162, and here oral evidence or documentary evidence. For some offences there is a special procedure in the Criminal Procedure Code recording statements under section 164 before a magistrate within a stipulated time after the occurrence of the alleged offence. This is there in offences against women. Offences against women. Say, I don't like to use certain words, but yet you all people know after having gone through the Indian Penal Code, all these words, offences against the woman. So that particular chapter deals with 376 and other 354, 509. So in those cases, within 24 hours from the registration of FIR or alleged occurrence, the police should array the victim girl before the Honorable Court and get the statement under 164 Criminal Procedure Code. Why? Why this procedure lays down on the woman, do you know? See, there is a possibility to threaten the witness that she will be killed, or to win over the witness, that is there will be business of payment of money, or some such foul games before the trial commences. So to avoid that will be recorded. That is another type of. This statement comes as a confession statement. In addition to 161, 162 procedure, this 164 procedure is a confession statement. See, even while recording these confession statements, under section 163 there is a procedure called that those confessions should be done without inducement, without coercion, without any other undue influences upon the witness. Okay. Next, in the course of physical evidence, the question of seizure of property used for the offences. Search and seizure procedure alone takes 1 hour class. I don't discuss search and seizure procedure here because there are about 6 sections which confer rights upon the that is prosecution agency, that is the police, to secure evidence by way of seizure of property from the possession of the witness or accused, and at various stages from the dwelling houses of the accused or witnesses. Section 47, Section 52, Section 94, Section 100, Section 102, Section 103, seizure of property in the presence of the magistrate, and Section 165, immediately after registration, police can enter into any dwelling house or any place of the accused or other witnesses and seize the property. All these sections are applied, and if at all they have to be discussed, it takes time, I don't discuss that. After this physical evidence, this is scene of offence is completed, and confessional statements, registration, 4 items are over up to this stage. So now, after this, you have other evidences, such as expert evidence, material objects. So material objects in the place of offence, the scene of offence, the material used by the accused to commit the offence, or the sufferings of the victim might give clues are gathered. So that evidence also will be taken into consideration. Material objects, evidence of material objects. So expert evidence is something like handwriting, all these things. See, one will say that the girl committed suicide and this is suicide note. That fellow might have done so many things to create that suicide note. That is in the handwriting. Whether that is the handwriting of the girl or not, nobody knows. So expert opinion. So all these are various types of methods to muster evidence by the police agency, that is prosecution agency. After mustering of evidence, what the police should do in this court? Here, in the course of investigation, mustering of evidence, what all is to be done, what are all the records to be maintained in the police station, I will discuss. When some girl goes to police station, gives a complaint, okay, that man does everything, because routine thing is to register cases given by the girls. Some man strangely goes, sir, నా భార్య దుడ్డు కొయ్యతో కొట్టింది సార్, నా దగ్గరికి ఒక కేసు వచ్చింది చెప్పాను, నా భార్య దుడ్డు కొయ్యతో కొట్టింది సార్, చెయ్యలేకపోయింది సార్, పోలీస్ స్టేషన్ పోతే పోయా. ఎందుకంటే ఇన్ ద పోలీస్ రికార్డ్స్ దెర్ ఈస్ నో ట్రెడిషన్ ఆర్ కస్టమ్ ఆర్ యూసేజెస్ ఆఫ్ రిజిస్టరింగ్ ది కేస్ గివెన్ బై ఎ మేల్ అగెన్స్ట్ ఎ ఉమెన్. సో దానికి పోయి పోలీస్ స్టేషన్ వచ్చే. So that is the answer. But what the Indian Penal Code says, ఏం చెప్తుంది ఇండియన్ పీనల్ కోడ్? Wherever this code carries the word he stands for she stands for he. So substitution is there. So not only the case of a female that should be registered, even the male may be a victim. His case also should be registered. Let us take the statistics of Indian police stations and see how many cases are registered on the basis of complaints given by women. నేను ఇంకా అసహ్యమైనటువంటి ఉదాహరణ చెప్పకూడదు, నా దగ్గరికి వచ్చినటువంటివే అసభ్యకరమని అనిపిస్తుంది, నా ఏజ్ తగిలిపడి కాబట్టి. That is not the correct. The Indian mindset, psychology and criminology, you should study. The legislators should first of all study psychology and thereafter initiate the motion of ordinance or a bill. Without that, I don't want to speak psychology on the dais because I have knowledge of psychology learned through literature, many novels, but I don't cite those because you feel wastage of time. But psychology and criminology, that is what is the reliance of criminology on psychology. That is also there. Without the study, psychological studies of mindset, the legislators frame laws which become utter failures in the course of time. That is finally, for that the best example is 498 cruelty offense. 498 cruelty ఎప్పుడు వచ్చిందో తెలిసినా? ఏ ఇయర్లో వచ్చిందమ్మా? గర్ల్స్, యూ మస్ట్ బి అవేర్ ఆఫ్ ఇయర్ చెప్పండి చాలు. 1983 on the birthday, as a birthday gift of the then Prime Minister Indira Gandhi. 19th November, that had come into force. It is a birthday gift of Mrs. Indira Gandhi to the women of India. Then the offence was cognizable, non-bailable, non-compoundable. ఇది మీరు ఇన్వెస్టిగేషన్ ప్రాసెస్లో వేస్ట్ అనుకోకండి. ఎందుకంటే when the law was made, it was so stringent that the offence was cognizable, the offence was non-bailable, the offence was non-compoundable. ఇప్పుడు here how many outsider people from state Andhra Pradesh who do not know Telugu, I do not know, but if this issue is discussed in Telugu, it will be more understandable than in English. That is the disadvantage for me to explain to you. Non-compoundable అంటే తమిళ్లో కొంచెం சொல்லுவேன், எனக்கு தெரியாது. ఇంగ్లీష్ non-compoundable means that issue cannot be compromised. మీకు ఇక్కడ ఒక ప్రొసీజర్ చెప్తానండి. క్రిమినల్ లాలో నాన్ కాంపౌండబుల్ అఫెన్స్ లో వాళ్ళిద్దరూ, దట్ ఈస్ బోత్ పార్టీస్ గెట్ కాంప్రమైజ్డ్ by reason of various factors such as the influences exerted upon the couple or upon the victim or upon the accused by the relatives or friends or others, taking into consideration different situations of prevailing in different case laws, an issue can be compromised. Raji person, wife and husband పోరాడుతున్నారండి ఏదో కారణం వల్ల, వాళ్ళ వల్ల వీళ్ళ వల్ల జరిగిపోతుంది, మర్యాదలు లేని దాని వల్ల. దట్ ఈస్ కాల్డ్ టీచింగ్ ప్రాబ్లం. ఆ టీచింగ్ ప్రాబ్లం వలన జరగదు. సమ్ పీపుల్ కాంప్రమైజింగ్, బట్ ద అఫెన్స్ ఈస్ నాన్ కాంపౌండబుల్. కోర్ట్ ఆల్సో హ్యాస్ నో పవర్ టు కాంప్రమైజ్ ది ఇష్యూ. ది ఎఫెక్ట్ ఏమో, వుడ్ యు అండర్స్టాండ్? No husband who had been behind bars on the basis of the complaint given by the wife had reunited in the judicial history of India. That is the comment made by the judges in some of the cases. It is not my comment, please. When once the husband goes behind bars and comes out, these people did not unite. But in cases where the husband did not go to jail, yet the problems were so complicated that the ordinary people could not resolve, and with all best efforts of some people, they are united. Even some of the friends also, good mediators, they also united. In such situations, after a lapse of time, they forgot everything that had happened and reunited. That is why that had practically become a bailable offence as per the judgment of the Honorable Supreme Court of India in Ornesh Kumar versus State of Bihar. Now, compoundability. ఈ కాంపౌండబిలిటీ క్లాసిఫికేషన్లో నాన్ కాంపౌండబిలిటీ అయితే కాంప్రమైజ్ చేయడానికి ప్రొసీజర్ ఏమి? Do you know what is the procedure to be followed to compromise a case between two parties, that is the accused and the victim, if the offence is classified as a non-compoundable offence under the Indian Penal Code? This is a question. ఏం సార్ ఇంత పెద్ద క్వశ్చన్ ఉంటే మాకు ఎట్లా అర్థమవుతుందంటే నేనేం చెప్పలేము. క్వశ్చన్ వన్ సెంటెన్స్ స్ప్లిట్ చేస్తే సెంటెన్సెస్ యొక్క ఎఫెక్ట్ తగ్గిపోతుంది. ఓకే, దాని ప్రొసీజర్ ఏమంటే under section 482 of the criminal procedure, inherent powers of the High Court, which is a constitutional court, both parties should file a petition, criminal petition, seeking compromise on the grounds mentioned in the petition. And the Honorable High Court of the state concerned will call both the people. Aduguta, ఏమమ్మా నీవే కాంప్రమైజ్ కంప్లైంట్ నువ్వు వేయించావు, కాంప్రమైజ్ పిటిషన్ కూడా వేసావు, కోర్టు టైం వృధా చేసిన వాళ్ళు ఉండరు. ఎందుకంటే మళ్ళా వెళ్ళిపోతే కాంప్రమైజ్ పోతుంది. కాబట్టి ఇప్పుడు నువ్వు విత్డ్రా చేసుకుంటున్నావు, నీకు సమ్మతమేనా? నీ మీద ఏమైనా ఒత్తిడి ఇచ్చినారా? వాజ్ దేర్ ఎనీ undue influence upon you to compromise the situation? All these questions will be raised by the judges. If the answers are pliable, then the court will order compromise, and on the basis of that court order of the Honorable High Court, the lower court will pass an order of compromise and close the case. That procedure was there. See, why I tell this in the process of investigation means very simple. This procedure is not known to many of the friends in the lower courts. This procedure is not, but youngsters, if you know this procedure, you can settle so many issues between the couples to avoid litigation before the courts and waste of time of the trial courts. Now, having considered the number of cases in which the couples had compromised and the offence is compounded on the basis of these petitions under inherent powers of the High Court, section 482 CRPC, the court delegated, Honorable High Courts delegated these powers to the district courts, So with the approval of the district courts, the trial court can compromise the issue. Now, what is my idea? Investigation, the procedure for investigation, how it had been diluted from the level of a cognizable offence to a very simple case, and the level of a non-bailable offence to the level of a bailable offence, and from the level of a non-compoundable offence to the level of a compoundable offence. These three factors conjointly gives us that the procedure of investigation, if is stringent, is not enough to maintain the good society. The procedure of law framed at the time of legislation should be pliable, useful to the society on the practical and experimental parameters of the society. So I am giving this as an example. Now, in this regard, 498 and other things, serious offences category, I explained, petty offences category, I explained, grave offences come under some property offences, more or similar warrant cases, trial of warrant cases by magistrates, that procedure uniform. And now I come to heinous crimes. Heinous crimes. What is a heinous crime as per the classification of offences? What is the yardstick to classify an offence as a heinous crime? 10 years or above imprisonment. 10 years or above imprisonment, or imprisonment for life, or death penalty. Now comes the importance of Article 21 of the Constitution. No person shall be deprived of his right to life and personal liberty except by due procedure established by law. That due procedure established by law is to be strictly followed in the context of this heinous crime classification. See, death penalty cannot be given so easily. Likewise, life imprisonment. Life imprisonment means imprisonment for what time? Huh? Okay. Huh? 14. Minimum 20 years is to be completed. At where there is a remission, if 14 years is enough, and after 14 years remission can be done under Article 72 of the Constitution in case of offences covered under the central law, and under Article 162 in case of offences punishable under the state laws. Okay? Death penalty. Now, imprisonment for life, investigation process unna kuda దీనికి ఏం కండిషన్స్ ఉన్నాయి? You all know what are the conditions laid down for life imprisonment, how much time he should be in prison, how much remission he will be given, and 10 years and above offences also you know pretty well. There is no death penalty. Death penalty, what is the procedure for imposition of death penalty? Because no person shall be deprived of his right to life. Death is a deprivation of right to life. Death penalty is a deprivation of right to life. But some of the people raised a question before the Honorable Supreme Court of India that this death penalty is in conflict with fundamental right to guaranteed under Article 21 of the Constitution, that is right to life. This question was raised in the case Gurbachan Singh versus State of Punjab. Gurbachan Singh versus State of Punjab. Sometime in 1973 or so, I don't exactly remember the year in which that judgment was given. But there is a stringent procedure established by law. What is that stringent procedure? So this, all this becomes part of investigation to ensure that investigators should not violate any of these rights. In the gathering, material objects తీసుకొచ్చి పెట్టేయడము, కొన్ని వెపన్స్, ఆర్మ్స్ ఎక్కడ దొరికిందంటే ఆర్మ్స్ పెట్టేయడము, లేకపోతే గంజాయి దొరికిందంటే నార్కాటిక్ డ్రగ్స్ అండ్ సైకోట్రాపిక్ సబ్స్టెన్స్ యాక్ట్ పెట్టేయడము, ఇటువంటివి కొన్ని ఉన్నాయి. అన్లాఫుల్ యాక్టివిటీస్ ప్రివెన్షన్ యాక్ట్లో దెర్ ఈస్ కనెక్షన్ టు మార్క్సిస్ట్, ఇటువంటివి జరగకుండా ఉండేదానికి ఇన్వెస్టిగేషన్ ప్రాసెస్లో మనం తీసుకోవాల్సిన స్టెప్స్ ఉన్నాయి. సో బికాస్ దట్ ఇన్వైట్స్ డెత్ పెనాల్టీ. సో విత్ దిస్ ద ఇన్వెస్టిగేషన్ మెథడ్స్ అండ్ ప్రొసీజర్స్ I have already explained. In case of heinous crimes, you as a practical lawyer, good lawyer, the guardian of law of the accused, guardian of law to the rights of the accused, you have to protect them. Therefore, my dear students, if there is an occasion, you will be apprised of the death penalty and the procedure to be followed to impose the death penalty, and whatever the various offences covered under the Indian Penal Code with the death penalty. So, with this, I conclude the investigation chapter. Much obliged.
Thank you.
Thank you, the Secretary Garu, for enlightening all our students on crime and investigation. There are a lot of techniques in the investigation process. There are a lot of techniques in letting the evidence. There are a lot of techniques in creating doubts in the minds of the judges so as to win the case. Right? I just give you one example so that all of you are feeling already hungry. I think you will get angry when I continue. Tell you one or two instances. Take for example, when the evidence is written before the court, as our Secretary was referring, the entire material should be placed before the court, entire evidence. While letting the evidence, if certain things are not brought to the notice of the court, it creates doubt in the minds of the judges and the judgment will be in favor of the accused. You know very well. In one case where I was appointed as an assistant public prosecutor because the accused, this prosecution side, the deceased husband and their brother-in-laws, they don't have faith in the public prosecution. Then what is to be done? They file a petition before the court and they appointed me as an assistant public prosecutor. When I was watching the public prosecutor while the evidence is let in, he is trying to avoid marking of the properties which are used for committing the offence, for killing the deceased. They use weapons like axe, sickle, etc., etc. They are not being brought to the notice of the honorable court. Simply, the public prosecutor, he was not touching these weapons used for committing the offence. Then suddenly the case will be in favor of the accused. So this is a technique. How even the public prosecutors on payment, as I was referring, quid pro quo. If something is done for the public prosecutor, some amount is paid to the public prosecutor, he will try to help this accused by not letting the full evidence. So they will use the case. Then coming to the other one, non-compoundable cases as was referring, you cannot go for compromise. Then generally what we used to do in Kadapa district, the political leaders or the elders of the village, they used to follow certain procedure. What is that procedure? They will make the witnesses hostile. Of course, on payment. They anyhow that fellow, he was killed, he cannot come back. So pay something for that family. So ultimately they will. Then by letting the evidence, what they do is, suppose I am a lawyer, letting the evidence on behalf of the prosecution. I will ask, our principal is witness. I will ask this witness whether you know the accused. No, sir. Whether you know the witness. No, sir. Whether you know how this offence is committed. I don't know, sir. Now, here in the case, he is a hostile witness. He will be treated as hostile witness. Right? So, all these techniques are there when the case cannot be compromised. Then they use these methods to come out of this. Thank you, my dear students, and as a mark of respect, we felicitate our today's guest, Ll.B. Secretary Garu, in the presence of all the students. Thank you. We will go for demonstration.
He's good.